guidance that moves lives forward.
Hi, I'm Wendy, and this is Divorce Doesn't Suck. I'm talking all about the life you can live after divorce. You'll hear regular people's stories about their divorces and how they reinvented themselves and grew. You'll also get invaluable advice from experts who serve in the divorce community. A little about me. I'm a former TV producer and mom of two. I got divorced in 2008 when there were really no outlets or platforms for me to turn to. So I'm paying it forward and have created a platform to help men and women learn that there absolutely is a fresh, new, and exciting life after divorce. Come with me on this journey and paint your brand new blank canvas of happily ever after divorce. This episode is brought to you in part by the Cuda Law Firm, guidance that moves lives forward. Welcome to another episode of Divorce Doesn't Suck. I'm your host, Wendy Sloan. And today we are back with our series, Mapping Your New Path Forward, with attorney Kevin Brown from Cuda Divorce and Family Law. Today we are talking about frozen embryos and divorce in Connecticut and much more than that. Such an important topic, not talked about enough. Welcome, Kevin Brown.
Thank you. Pleasure to be here.
I have to say that this topic is so important. I don't think it's the first thing you think about when you're talking about child custody, support, adoption, but frozen embryos can play such a huge role in divorce and support. And IVF now becoming so much more prominent because people are getting married later in life. The women out there are working now. They're not just, getting married at 20 and 22 and 23 right after college. And they're in the workforce. So this is really a very, very important topic today.
That's right, Wendy. And it's something that we're also seeing more of in our practice here. We're having more and more clients coming in who have frozen embryos in storage, sometimes going back, quite a few years, and determining what to be done with those embryos in the course of a divorce action can become quite challenging, as you might imagine, given that for some people, those embryos are the only remaining opportunity, realistically, to have a genetic child of your own.
Right. And I've heard stories of women, young girls that are going into the workplace, and they're worried that, well, maybe I'm not going to get married so young anymore, and I'm going to go out and do this on my own too. And I'm going to go freeze my embryos. But what kind of agreement is there when you're with your partner and you are going to be, whether you're married or whether you're engaged or whatever, you're going to freeze your embryos. Is there an agreement going into this, not just with the partner, but with the place that you're doing it?
Yes. Typically at the outset of the IVF procedure, the clinic will present the soon-to-be parents, the hopeful soon-to-be parents, with an agreement. It's often called a storage agreement, because when you create these embryos, any leftover embryos that are not immediately implanted in the woman to start a pregnancy, those will go into cryo storage, and there needs to be an agreement setting forth the terms for that storage. And within that agreement, there will be typically check boxes indicating what will happen with these embryos, for example, in the case of a death of one of the parties or divorce. And so these forms, they're often filled out. We get the sense that people don't spend a tremendous amount of time thinking about them because, again, you're looking at that moment at the positive, the hope of having a child. You're trying to get on to the next phase, of which is having a child. You're not sitting down seriously thinking about, well, what if someone passes away? What if our marriage doesn't survive this? So it seems that people come along and they check these boxes, sign the form, and don't give it too much thought. And what we're seeing in our practice is years and years later, when there's a divorce and these embryos are still sitting in storage, these contracts sort of rear their ugly heads. That creates tremendous difficulties for people, again, depending on the facts and circumstances of each individual case.
So in simple terms, what are we talking about here?
Well, we're talking about a couple going through a divorce where you have one of the parties wants to retain these embryos for the purpose of having another child after the conclusion of the divorce case. And as you might imagine, that is an extremely emotional and difficult issue. On the one hand, you'll have the party who wants to have the child from these embryos, and their position might be, this embryo is my only shot at having a child or another child. And it can be the man or the woman. It's not, it's more often the woman, but it goes both ways. And on the other side, you have the other party who does not want these embryos to be implanted in anyone and does not want a child born from them, because that raises questions about becoming a parent against your will.
Right.
Very difficult issues to navigate, and the law really is unsettled. The courts have touched on this a little bit. There is some legislation in place, but it has not. It is far from a completely settled issue, and that uncertainty creates difficulty as you're trying to resolve and litigate divorce actions.
So are they taking, is the states taking steps in determining who has the access to the frozen embryo for either, I hate to say this word, destruction, I don't really like that word, but that's what it says out there, or implantation? Tough stuff. This is tough stuff.
It's very tough stuff. We have some appellate case law in both New York and Connecticut addressing this issue. In both of those cases, the parties had signed a contract that called for, in the case of a divorce, destruction, or the other term that is often used in the contracts and in the legalese is discarding these embryos. And in both of those cases, ultimately, the courts decided to uphold the agreement on the logic that this is what the people chose at the outset, and the courts should enforce their agreement. But what those courts have not been confronted with, at least as far as we've been able to tell, is what if the agreement had called for something different? What if the agreement had provided that one party or the other has the right to do what they want with these embryos? And that, again, would raise this question about someone becoming a parent against their will. So we haven't seen the courts address that. It's completely unsettled. There has been some legislation in place recently in both New York and Connecticut that will address some of the follow-on implications for who is a parent of a child born from an embryo created during a marriage that's then assigned to one parent over the other. But again, it's very much an open area, and it creates a lot of uncertainty. And given the emotion that follows this issue into these divorce cases, it makes them very, very difficult to settle sometimes.
I can't even imagine. And I would imagine that this would be getting appealed and appealed again and again, especially for someone who says, wow, this is my last chance at becoming a parent.
That's right. That people who really feel strongly about it, about, this is my last chance to become a parent, as you said, you're faced with taking your divorce case, pushing it all the way through to a trial, which, and I'm sure you've talked about on this podcast quite a bit, can be an emotionally draining as well as extremely financially draining endeavor in itself. Then, you have to prepare yourself for an adverse outcome at trial, or even in the case of a win at trial, that is then going to go up to your appellate courts and then ultimately up to your state's high court, because these are issues, again, that have not been completely resolved in the past by either the state high courts or by the legislature. And so the road is very, years and years long, and the cost to do this with appeals and a trial, et cetera, is just tremendous. And so people are put in this position of, can I afford to do this emotionally and financially, or do I have to just sort of lay down my arms here and accept a resolution that I don't think is fair or right?
And then I'm thinking even further out, just as a mom, I'm thinking this. So say you have frozen embryos and you win, and you're the mother, and you are able to keep them, and you are able to have a child, and the X is discarded, and then you have this child. So this child does not have the father. What happens when this child grows up and wants to see the father, but the father has no rights?
Well, that's right. And so you've raised sort of the question of what happens in the first instance when this child is born to the mother in that case, is the genetic father the legal father of this child, or vice versa. The mother the legal mother. And there has been some legislation in this regard to help sort of give some certainty here, but in my mind, it's still not completely resolved. So it raises the possibility that someone may become a genetic parent against their will and then not be considered a legal parent of this child, which in my mind creates all sorts of other problems. So yes, legally, maybe you might not be considered the father for purposes of having to financially support this child, but you're also in that case not the father for purposes of pursuing any kind of relationship with this child for custody purposes.
Right.
And, there are, that could be sort of an abstract problem, but think about a scenario where the family has children and now there's another child born after the divorce. So now you have you have your own children of the marriage. You're the father. And then there's another child born who's also your genetic child, but you don't have any custody rights to that child. You're not legally the father. I mean, that's a very tough situation.
Very tough. Very tough. Where do individuals and human rights fit into the current equation right now? I assume this opens up major floodgates.
The short answer to that one, Wendy, is the courts have taken or gone to great pains to try to avoid framing this and deciding these questions from the perspective of human rights. They will have acknowledged that it's not quite a question of property or contract entirely, but they are staying far away from determining that, oh, well, this is human life and we need to treat it as such when we're making these decisions. As you might imagine, that's sort of a loaded issue that opens up its own can of worms potentially. So the courts, and it becomes ultimately sort of clinical that the courts have sort of refused to look at it that way. That's how people think about these issues, but the courts are looking at it from the perspective of, is this embryo property of the marriage? What did the people contract to do?
I think it first came to light, for all of us when Sofia Vergara had her frozen embryos and she was fighting. Her ex wanted to get the frozen embryos. I think that's when we all started realizing, wow, I don't think we thought about it before. Can you share some of some stories from your office, from what you are seeing, what you're dealing with?
Well, the interesting thing about the Sofia Vergara case, and I'm not an expert on that one, is I believe the actress that Sofia Vergara in that case, she was looking to have those embryos not implanted in anyone.
Correct.
I'm not sure if she was seeking to have them discarded or destroyed, but her romantic partner, the boyfriend or fiance, whatever he was looking to go have children with them. And again, that's the circumstance where the courts have not had as much trouble. They seem to be much more comfortable going with the party who says, I don't want to be a parent against my will. We've agreed in advance about what's going to happen with these embryos, and they should be destroyed and not implanted in anyone to create a child.
What are you seeing more in your practice, and can you share a story?
Yes.
Some stuff that's going on in your practice with this.
Okay.
Obviously not specifically names and all that.
Well, of course. So I'll just speak sort of in generality here. We have seen a case where the family had a child and they had embryos in storage, and the mother desperately wanted to retain control of the embryo so she could have more children. And the father in that case took the position that he didn't want to have any more genetic children. What would it look like if I came to drop off my child at mom's house and there's my own genetic child, at the door waving hello to me? We've seen that. We've seen cases where when we reach out to the in vitro fertilization clinic to ask for a copy of the contract that the people signed, 5 or 8 or 10 years before, they say, we can't find it. We don't even have the contract.
Really?
Or it looks like we've made a mistake and we don't actually think that we had these people sign anything. And that leaves you, completely in uncharted territory legally. We've seen cases where embryos are in storage and the mother comes down with some kind of awful illness, which renders her unable to have any further biological children of her own. And the embryos represent the only chance to have a child. And in that case, the father, as you might expect, says, I don't want to become a parent against my will. We're getting divorced. I don't want to now have a child with you afterwards. That would just further entangle us together when we're trying to make a clean break. And these are things that, lawyers, we can't really resolve for people because the law is unsettled. And it's more difficult than, for example, in a divorce, figuring out who gets the money from the proceeds of the sale of the marital home, right? Is it 50-50? Is it going to be 60-40 or 55-45? These are issues that have a winner and a loser. Like either there is going to be a child born and a party's, wishes and hopes and dreams of becoming a parent will come true, or not, or you lose. And given how fundamental this is to people's lives and their priorities, it becomes very, very difficult to resolve these cases. There's not a compromise, really.
We're back with Kevin Brown, Mapping Your New Path Forward, Frozen Embryos and Divorce. I got to say, that must be so hard for you guys. I can't even imagine.
Well, it is hard for us. It's not as hard for us as it is for the clients.
For the clients as well. But I mean, this is like you said, not just dividing who's going to get half of the house and who's going to get this piece of furniture. We're talking about a frozen embryo. I mean, we're talking about a life that could or could not be born, and such a important topic today that we need to talk more about.
Well, that's right. And we end up, unfortunately, in this position where we have to counsel people about the unsettled nature of all of this. And we have to explain to them that the path forward is either reach some agreement that you may not be comfortable with, or prepare yourself for this long road of a trial and appeals and all of that may go on for a period of years and years,
more money spent.
Tremendous expense. And so this becomes a frustrating issue for us as attorneys because we are left without a framework within which we can advise clients on a clear path to an outcome that they want.
So how do you see this moving forward? How do you see the courts handling this? How do you see things playing out with this as it's becoming more prevalent now that this is happening more and more?
Well, you're right. We are seeing it more and more. And I think we're going to need legislation on this is my sense of it, that the issues around what happens when a couple presents this issue to a state high court where the result is a pregnancy and a birth of a child against someone's will. My opinion is that the state courts are going to be very uncomfortable with that proposition, and I'm not sure what they'll do with it. So to some extent, we have to wait and see when those test cases really get brought to the state Supreme Courts. But I suspect the legislature may have to act further. They've taken some steps to deal with the issue of, well, who's legally a parent in this case? Again, they've not completely addressed that, but they've taken some steps. I think they'll have to take more to really resolve this. I'm not sure if it's something that the state courts can or will be comfortable making final pronouncements on.
And the host of these frozen embryos, do you think there's going to be changes with where they're hosted, with the places?
That's an That's an interesting question. I mean, I mentioned earlier that these embryos get stored under these contracts that are, if they're not actually presented to you on a clipboard in the waiting room, it's, just one step removed from that. I think that there is an opportunity for the clinics to improve these agreements and improve the process by which these agreements are executed, so as to make clear to people, you need to think now about what will happen in the future if there's going to be a divorce or a death.
Mm-hmm.
We would, we're hopeful that you're going to be on your merry way with a happy and intact family with children, but we have to have a clear-eyed view at, the unfortunate circumstance and what's going to happen to these embryos. Then I do think what can be done there. And
I was thinking about that because I recently did an interview. We were talking financial clarity. So basically, one of the big reasons people get divorced, right, is because of financial issues. So here we are, we're in our we're planning our wedding, we're in our honeymoon stage, and so we should talk about finances now while we're happily stepping into this chapter of our life, rather than we're getting divorced and what's the finances and I don't know anything, and et cetera, et cetera. So put something in play financially that's like a legal piece of paper, just like maybe the clinic should do. This should become more, we should step up. The clinic should step up, maybe, perhaps, with this.
Perhaps. And, one of the things that we've been talking about here at our office is whether to supplement the choice that parties make when they're entering into this contract with the clinic, whether the parties should consider some form of a postnuptial agreement between themselves, with the benefit of independent advice from attorneys, to make an agreement separate and apart from whatever's going on with the clinic about what will happen to these embryos in the case that there's a divorce. It's hard to say whether that would upend the result in a later court proceeding, but it seems like it can't hurt. Anything that can be done to give further comfort to a judge later on that two people made free and voluntary choices about what's going to happen if there's a divorce and there are still embryos in storage can only be a benefit.
I agree. So can we talk about some of the stats with this? Because I realize that IVF is now, it's up. It's up big right now.
Right. We started thinking about this issue because we had noticed a wave of cases coming into the office where this is either a contested issue or even, and we have many more of these cases where people come into the office and yes, there are embryos in storage. And as you're working on financial disclosures and people's expenses, there will be a charge for the yearly storage with the IVF clinic. And so it's something we see a lot, even in cases where it's not contested. So we can tell that the prevalence, the frequency with which people are undergoing IVF is increasing. And we look back at some of the information from the National Institutes of Health and other relevant government sources, and confirmed, yes, that it has been increasing since over the last 10 years, roughly. First IVF procedure was done in the late 70s, and it seems to have been growing since then, but even at a greater rate over the last 10 or so years.
So how do you see this playing out in your office and going forward?
Well, we're in, to some extent, we're in as much of a pickle on this as the clients are. It's challenging for us because it's difficult to give advice. What we end up speaking to clients about is, again, the fact that this is unfortunately a binary issue. There's going to be a winner and a loser if the parties can't reach an agreement here. That it's not something that we can get full clarity on for quite some time, right? There's a whole process to sort of become that test case, that guinea pig.
Right.
And so we advise people, that they need to reach some kind of a settlement. But unfortunately, again, that means agreeing to be the winner or the loser, and it's never completely satisfying. And so it's a frustrating issue for us as attorneys as well.
So without some kind of law, I guess the courts and the judges, they don't really have much information as well.
That's right. I mean, it's an issue that would be, I think, a difficult task for a trial judge to take on, because the trial judges look to the legislation, they look to what the higher appeals courts have done, and there's not a lot of guidance here in that area. So yeah, it's a very thorny and difficult issue. There are not easy answers, and unfortunately, that's what we have to be candid and upfront with our clients about. That there's not an easy path forward to either ensuring that you can become a parent using one of these embryos, or that we can prevent your soon-to-be ex-spouse from making use of these embryos going forward.
Right. I imagine this is such a big topic, and here you are, you're sitting there, you're going through how are the approach the court. Sorry, I lost my train of thought as well. I'm just thinking about here you are, and you're paying for storage while this is all going on. I can't imagine what kind of fee that is.
It's around $1,000 to $2,000 a year to store these embryos in our experience.
Okay. What approaches have the courts taken with this?
So courts around the country have taken generally one of three different approaches. The first and seemingly is the more prevalent is this approach of leaning on a contract that the parties have executed at the time the embryos were put into storage. And there has been litigation over whether a check the box form is really enforceable. Is that really a contract? Is there really a meeting of the parties' minds on that? Generally, the courts have come out and said, yes, it is a valid contract. And again, the cases that we've seen there are cases where the contract provides that in the case of a divorce, the embryos are going to be discarded or destroyed, as the case may be. Other courts have looked, they've undertaken what they call a balancing approach. So they will really dig into the specifics of the parties' circumstances and sort of make an equitable determination about who should retain the authority to make decisions about these embryos. So, for example, if the embryo really represents someone's only chance to have a biological child, and you have a husband who could otherwise go out and start a new family on his own, maybe the court would say, well, we're going to tip the scale here in favor of the wife in that case.
Mm-hmm.
Or maybe there has been some bad behavior by somebody. For example, I think there was a case, I forget which state it was, where the husband had been a bad boy running around with other women. I think he may have had another family or something like that. And at the same time, they've got these embryos, and they're delaying starting their own family while he's secretly doing things he should not be doing. And in that case, the courts tipped the balance in favor of the wife. But that's difficult because that's just leaving the matter as sort of a toss-up, and it doesn't really give clear rules around this for people.
I was going to ask another one. What if one of the parties, what if in the marriage, one of the parties has is not going to be is dying, and then there's still embryos? Is there something with that? Can the other person still use those?
That's one that I don't know. I've seen that case litigated, but yes, you could imagine a whole separate set of controversies when someone is dying or has passed away. What then?
Are you able to use those because that person's not here and that person has no say? I mean, what happens?
Does the estate's executor get a say then in what happens to these embryos? Yeah, so there are lots of ways that this issue, I think, will be rearing its head going forward as IVF continues to become popular. And just before I go, or I forget, the third approach that courts have taken, I think only one state did this. They called this contemporaneous mutual consent. And that's really just the court punting the issue and saying, we're not going to make any decisions about what should happen to these embryos. They're going to stay in storage unless and until you parties can agree on what's going to happen.
Well, I
You know,
kind of like that, actually. I kind of like that, putting it on the parties rather than that. I like that, Judge. Wow, I'm still thinking about what you said. That's why I lost my train of thought. I'm going back to, and I'm sitting in the doctor's office right now because I'm thinking about everything that you said. And here I am. You know how you go to the doctor's office and you have to check off all these boxes about what, you have this, and that's what they're doing when they're here, when they're about to freeze their embryos. They're about to go into IVF, actually, and they're checking off these boxes. I'm sure they're not really reading what happens if in the divorce and that box that gets checked off, that's just not enough.
Yes, in my opinion, the more could be done on the front end of this to help resolve issues later on. And yes, the people at that stage are not focusing on what if everything goes south here? What if our marriage can't survive this? They're focusing on the happy life that they want to build together, the prospect of a child. And they're not thinking, let me take this contract, let me go get a lawyer, you get a lawyer, let's everybody, consider our rights, et cetera, et cetera. So yes, in my opinion, the clinics could be doing more to address this.
Well, kudos to you guys, Needle Cuda and Kevin Brown, for bringing this topic to light and talking about this, because we need to talk about this a lot more, because I see, IVF on the rise, more women in the workforce, more people getting married later, having children later in life. This is a big topic. Any last minute thoughts you want to leave us with, Kevin? And thank you so much for this.
No, just to echo on your comment, we saw a paper from the National Institutes of Health indicating that in the coming years, as many as 10% of all children born in areas like the United States could be born from IVF. So it's going to continue to be an issue, and we need further work on this. And Wendy, thank you for having me. It's been a pleasure being on. Yeah, thank you so much. Thank you, Kevin. We'll talk about this again, I'm sure. Thank you. Thank you.
Needle Cuda, divorce and family laws attorneys, have guided Connecticut and New York families through complex divorce actions, contested child custody, and alimony disputes for over 30 years. Their Connecticut and New York attorneys have extensive experience in family matters involving substance abuse, domestic violence, mental illness, and many other X factors that can complicate a divorce. Their attorneys adeptly manage privacy and reputation concerns inherent to public divorce proceedings and the related exposure for their ultra-high net worth clients. Find your new path forward, define your post-divorce family, and secure an enforceable agreement to protect your future with Needle Cuda. Act now. Put the strength of their team behind you. Visit them at needlecuda.com or call 203-557-9500.
Guidance that moves lives forward.